Randall Harrison. I'm here on behalf of Al Tillman, who is the effective candidate in Chapman.
Okay. All right, and Mr. Cox, I think you had an objection to Mr. Harrison.
Well, Your Honor, I just don't think that Mr. Harrison is a proper party, or Mr. Tillman is a proper party to this proceeding. The party would be the Board of Elections, and Mr. Gibson was elected to file a challenge and was now filed.
Okay. Mr. Harrison, do you have a position or?
We don't know. Obviously, I'm very affected, my client's very affected, and we would like to participate in this proceeding to the extent that we would be able to suggest a proposed order in the case as well as our arguments in the case. We would ask the court to at least allow us to do that so that the court can be heard. As far as we establish the record in this case, so we feel like we do have an interest that needs to be protected.
All right, what I'm gonna do is, Mr. Harrison, I'll allow you to participate, and Mr. Cox, I know there's no objection, so just hold, do you have any legal grounds or any legal issues other than he's not an interested party?
Well, he's not a party, obviously, he's interested in the proceeding. That is the basis, he's not a party to the proceeding.
Okay, and there's not statutory or case law authority that would prohibit him from being a party, and I guess that's what I'm asking, the reverse question.
I don't think there's statutory or case law authority on either side of this question. Yes.
Then what I'm gonna do is ask, I'll let you participate, Mr. Harrison, but Mr. Cox, if you want to address it, with some citation or some argument in a letter brief, as I've told the lawyers prior to the proceedings, I'm gonna hold this case open to Monday to get their written response and proposed orders. So, Mr. Cox, you may want to address that separate, and Mr. Harrison, you might want to respond to Mr. Cox's issue as to.
Thank you very much.
Okay? All right. Mr. Cox, let me ask, from a moving party perspective, do you have any evidence?
Well, Your Honor, under 21-2-6, this proceeding has to proceed on the basis of the record that's before the court. And before, Your Honor, came in, the lawyers looked at the record with the court, and the record is complete. The only thing that we have not done was there was a sealed transcript file in the clerk's file that we did not open. And that sealed transcript should have hearing exhibits attached to it. And I assume it does, but if we could confirm that.
What I'm gonna do is ask all the attorneys step up here, and I'll open the transcript, and y'all, I don't know if it's in there or not, y'all look and see if it is.
This is being reported under the road, is that correct? Is that what I'm saying? It's going to be reported under the road. So we're not correct.
Yeah, the court has got a court.
You got we've gone through the exhibits, and they all appear to be part of the record.
Okay. All right, any other evidence on behalf of the moving party, Mr. Cox?
No, Your Honor, I don't have any other evidence, and I do not believe I'm allowed to present evidence.
Any other evidence, Mr. Nolan?
No, Your Honor, the Board of Elections is satisfied with the stand on the record, Your Honor.
Okay?
Thank you.
All right, now, since the evidence is in, any argument on behalf of Mr. Cox, technically as moving party, you would be opening and closing. Mr. Nolan, I guess you would go first. I don't care, one of you go first, like Mr. Cox goes
First, unless he waives it.
I'm delighted to go first, Your Honor.
Go, Mr. Cox.
And I know that we'll be giving you written submissions, so I will just be very brief, and really the purpose of this is just to kind of give you a very brief summary of what I will be addressing in writing, and also to let Mr. Nolan know what I will be addressing in writing, so that he can anticipate that in his response.
And all the attorneys, I'm not going to try to summarize what your argument is so that everybody knows what your argument is. You don't have to go into great detail now. You can do that in writing this afternoon, over the weekend, or whatever. I'm going to ask all of you to give me written proposals by Monday.
Your Honor, when you look at the statute that governs this proceeding, 21-2-6, E, there are several things that, or several instructions given to the court. First, the court can't substitute its judgment for that of the superintendent as to the way the evidence on questions of fact, which obviously means that's a typical appellate standard. The court, and then the statute says the court may affirm the decision or remand the case for further proceedings. That's one option that the court has. Another option is that the court may reverse or modify the decision if substantial rights of the appellant have been prejudiced because of, and then there's 6 factors listed here, Your Honor. And so in order to reverse or modify the decision, the court has to find that the substantial rights of the appellant have been prejudiced based on one of these 6 factors. The court does not have to make that finding to either affirm the decision or remand the case for further proceedings. And I will tell the court that we will be addressing in writing first the reason why the decision should either be remanded for further proceedings before the Board of Elections for taking additional evidence, or reversed based on one of these 6 factors. The reason for the remand of the taking of additional evidence, and I'll expound that in my written submission, is that I believe that the transcript shows first that the board was operating under the impression that there was only one factor that it was looking at, which was the homestead exemption of Mr. Tillman. And clearly there was more than that the board had to look at. So what the transcript, I believe, reveals that the board was operating under an improper standard. The second thing is that when you look at the comments of the board members in the course of the hearing, I believe that their comments show that they truncated some of the inquiry that Mr. Gibson wanted to be gone into during the hearing. And because of that, all of the factors that were appropriately considered in establishing Mr. Tillman's residency or domicile for election purposes were not gone into. And for that reason, I think it's appropriate to remand next week for the board to take further evidence on those matters. Case in point, I would anticipate if the court did remand this, that one of the things that would be gone into is Mr. Tillman's representation that his business is located in District 9. If an online search of business licenses is believed, he's not licensed to do business in any district. He's not licensed to do business in Macon. We would like to present evidence along those lines. His wife is licensed to do business in Macon, but that business is located in District 8, which is the residence located at 2572 Robinson Road. And there are other factors like that, and I think if a full inquiry had been made at the hearing and Mr. Gibson has not been cut off, those things could have been inquired into. That's why I believe that a remand is appropriate for additional evidence to be considered by the board, given proper legal standard they were operating under, and their presenting the evidence, Your Honor. The basis for the reversal is simply that the evidence does not show that Mr. Tillman established a new residency. What the evidence in effect shows is that he moved across the street or rented an apartment across the street, placed some items in that apartment, and took pictures of it to show at a hearing. And to use his words, he did that so that he could run in District 9. But there's no showing that he had a present intention to remain at that residence indefinitely. And one of the keys of how you know that is how Mr. Tillman responded to questions about the homestead exemption, because he was ambiguous about what would happen with the homestead exemption in 2014 when it had to be refiled. Would his wife refile it, which indicates his wife is going to still be living across the street in District 8 with his family. And so I think the evidence falls short of showing that he actually established a residence in District 9 on Bloomfield Road with the present intention to stay there indefinitely. That would be the basis for arguing for our reversal, Your Honor. That's just a brief summary of some of the issues we intend to present in our written submission.
Mr. Nolan?
Thank you. Now, may I bring the podium over? It's on wheels. That's long. Now, obviously, I disagree with a number of the statements made by Mr. Cox on behalf of the board. First, I'd like to point out that Mr. Cox discussed the standard for this proceeding, which is found in OCGA 21-2-6. And if Your Honor will allow me, I made a notebook with the record included as well as the relevant authorities, and I've prepared a table of contents for each of the other lawyers to inspect. May I hand this over to Your Honor? Thank you.
Before you go, let me make sure what this is and what it is.
Yes, sir, and I'm going to hand over to counsel a copy of the contents so that they can see what this is for. The first 8 tabs, Your Honor, are the record, including the transcript, and the last several are the applicable legal precedents.
All right, so you're saying tab 1 through and including 8 is?
Same record that's in the file. Yes, sir. Yes, sir. And the rest is just the statutes, 2 cases, and House Bill 514, which is the major Bibb County consolidation.
Okay.
2126E does govern this proceeding, as Mr. Cox stated. I'd like to back up, though, to A, B, and C, the same statute, which govern the proceeding before the board. And without going into the details, I represent to Your Honor that the procedures set forth in 2126, the first several subsections, were followed to a T by the board. There's been some implication by Mr. Gibson that he was not given certain rights and that he was cut off. That's simply not true, and Your Honor will see that in the transcript. It's just not true. In fact, both parties were given unlimited opportunity to present any and all evidence they wished to present. They were also given the right to cross-examine any witnesses called to testify against them. In this case, the only witnesses that were called were Mr. Gibson and Mr. Tillman themselves. There was no attempt and not even an implication that Mr. Gibson was limited in any way. I understand what's being talked about. It's found on page 40 of the transcript, which is that Mr. Gibson handed a number of questions to the board members at the hearing. He wanted them to ask the questions. One of the board members said, "I don't feel comfortable asking these questions." Nobody ever told Mr. Gibson he couldn't ask them. In fact, it was explicit There's nothing in the record that would indicate that any board member had a misunderstanding as to the law in this case. The substantive decision made by the board is governed by OCGA 21-2-217. There are 16 factors listed in that statute. There's 1 through 15, but there's 4.1. And factor number 1 states the residence of any person shall be held to be in that place in which such person's habitation is fixed without any present intention of removing therefrom. There are other factors in here too that were applicable. There was an abundance of evidence submitted by Mr. Tillman. An abundance of evidence, Your Honor. There's a lease that was entered into on June the 20th. He qualified at the end of July. There was a lease entered into by Mr. Tillman for the apartment he now lives in, June 20. There was a deposit paid June 17. The lease is for a year. A big deal has been made of the homestead exemption. There's been no evidence submitted, there's none in the record, that Mr. Gibson claimed homestead exemption since he moved. He did that once a year, perhaps once a year. So a prior homestead exemption is not relevant. Now, if he were to claim homestead exemption next year for his prior home, I still don't think that would necessarily disqualify him, but it certainly would raise an issue. The truth is that all of the evidence submitted at the hearing pointed to the fact that Mr. Tillman had moved to District 9 with the intention of staying there. Now, did he do it for the purpose of moving to District 9 to run? It appears that he did from the record. But there's nothing in the law that would allow the board to rule him unqualified on the basis that he moved to District 9 for the purpose of run. That's not what the law says. The law as to residence for this particular election is governed by House Bill 514, which is in the materials. There's Section 6. And what it says is that in future elections, Your Honor, in future elections, that any candidate must live in the district where they're running for at least a year. But in the initial elections, at least the initial elections, Your Honor, for this new government, it only has to be that the candidate resides in the district where he or she intends to run on the date of qualifying. On the date of qualifying. And all of the evidence in the record shows that Mr. Tillman lived in District 9 when he qualified. And so the board didn't take sides in this thing. There was only one, I will submit to Your Honor, possible result that could have been reached. I suspect, based on what Mr. Cox said, that he's going to try and read into the thoughts of the individual board members, Your Honor. There's 5 members on this board. The vote was 4-0 with 1 abstaining. I would submit to Your Honor that you cannot read into the rationale of one particular board member as to why they voted. I think this decision has to be made on the record and whether the decision was consistent with the record. I will also tell Your Honor that none of the board members said anything that exhibited a lack of understanding of the law, and that they were quite prepared and quite diligent and quite fair with both of the parties. And I think the record will bear that out, and I don't think there's any question about it. There's been the idea put forth that the way 21-6D reads, that this court can remand the case without having to find any error. And I've read the statute, and I understand why Mr. Cox reads it that way. But I would simply ask the court this question, and ask the court to consider this question: why? Why? There's got to be a reason to remand the case for further inquiry. Mr. Gibson wasn't cut off. You're almost see that in the transcript. He wasn't kept from saying anything he wanted to say. And you heard Mr. Cox, what did he say? Well, we want to refute some of the things that Mr. Tillman said in the hearing. That's not a proper reason to reopen this. We'd be reopening it over and over and over again if we were to do it on that basis. So I would submit to Your Honor that there needs to be a finding of error. and I submit also that the court will not find one, to remand or to overrule the decision of the board. The record will show that the evidence supported the finding as to numerous factors, not just factor 14, which deals with the homestead exemption. There is evidence in the record to support a finding in favor of Mr. Tillman under, and this goes to OCGA 21-2-217, as to factors 1, 7, and 15. Those all support Mr. Tillman's position and support the board's decision. And I would like to point out one more thing in the record, and I'm not going to go on any longer, Your Honor, but I do want to point one other thing out. On page 21 of the transcript, Mr. Gibson was asked to summarize his evidence. And the question for Mr. Harrison was, okay, so you're basing this totally on the homestead exemption, nothing else. And the answer is, and the fact I feel strongly amongst some other things that I can't bring out. Amongst some other things that I can't bring out. But I strongly feel that Mr. Tillman just flat out lied when he said he didn't live at that address number. He said it, said he didn't live there over there anymore in the paper. That's my problem. So that was the evidence. The homestead exemption. That's it. And things that couldn't be brought out. That's what the evidence was that was relied upon. That's simply not enough. And there's a Supreme Court case which included the materials, Handel versus Powell, that says that you can't rely solely on the homestead exemption. There's also a factor in 217 that says that one spouse's residence, for the purposes of being a candidate, can be different from the other spouse. And there's a case which is also included in your materials that upholds that rule, and that is Dozier versus Baker. And it's tab 14 of the notebook. And there's a direct quote in that case that says, this has to do with the Public Service Commissioner and whether he lived in the district where he was commissioner. Commissioner Baker's evidence is not refuted by the fact that he still uses and pays expenses for the DeKalb County home, which is now wholly owned by his wife, and for which she claimed homestead exemption in 2004 to 2006. Either the domicile or the residence of one spouse is presumed to be that of the other spouse. So the argument that Mr. Tillman's family or wife still lives in District 8 and that his wife made plan to claim homestead exemption is not relevant. It's not enough. You can't do it based on that. The presumption, there is no presumption that two spouses have the same residence. It can be different. Well, but again, Your Honor, I think what you're being asked to do is reopen this proceeding and reweigh the evidence. And I would submit that unless Mr. Gibson can identify substantial rights that the statute says that he's been denied, that the court should uphold and affirm the decision for the election. Thank you, Your Honor.
Harrison?
I think the board clearly acted on what Mr. Gibson presented to them. When he filed the objection, he clearly set out that he was filing it on the basis of the homestead exemption, which he read out of the statutes, clearly set forth in the statute. 21-217-14. However, apparently, he didn't read the case, which was a handle case, before he filed it. Because had he read that case, he would have realized that that was not determined in this case. In any event, he did come to that hearing after talking with an attorney. He actually had an attorney prepare questions, and then he submitted those questions and gave all of us a copy of those questions that were already written out that he said the board could ask. When you look at the statute that talks about what the board can consider, it says that they may consider these other things. It doesn't say they have to consider those other things. But really what I want to point out to the court is that Mr. Gibson had in his hands those questions that he thought were material to the hearing that was conducted before the Board of Elections. He was told that the board was not going to ask those questions, course, had the right to ask those questions. He did not do so. He had a right to bring an attorney with him. He chose not to. In fact, he commented on the fact that Mr. Tillman had an attorney in the hearing before the board. And of course, we're here today, and he's objecting to participating, and I appreciate the court allowing me to do so. Judge, the board went out of its way to follow the law in this case. They precisely went by the act that authorized the consolidation. And House Bill 514 provided that on the day of qualification, if you were a resident of that district, that was accepted. And that was passed by the legislature in conjunction with consolidation. It also has been heard by Judge Royal in U.S. District Court. And he said, proceed with this thing, everything's in place, and he gave the qualifying times for the re-qualified to reopen. Mr. Tillman had already established his residence before the qualifying ever opened, well before, a month before. So in anticipation of the re-qualifying period taking place, he took specific steps to establish his residence. And he just, he didn't just go down and get an apartment, move a couple of things in and take some photographs. He was living there. It is near his residence where he was residing before he moved his permanent residence, in which he clearly testified to. In fact, he went into the very things that Mr. Gibson is saying that he wanted to go into. He talked about where he worked at. He talked about where his wife lived. He talked about what their future plans were. All of that was in the record for the board to consider. He also established his residence by doing other things, and those things are part of the record. It was more than just, I went over there, and I think the whole idea is that the threshold for establishing residence is relatively low. It's based on the intent, but you have to carry out that intent. You have to show that you've done it. He did that. He went down and filed sworn statements saying that he was a resident. He registered to vote in that district. He changed his car registration to that district at that address. He received mail there. He paid bills there. He lives there. We think that the evidence was not only substantial, it was controlling in this case. And that record will be before you, and it's the only record there is. There is nothing to remand when the record is clear. There has been no procedural misstep by the Board of Elections. They have actually followed the law. They gave proper notice. They held a hearing that was fair to both parties, that was full and conducive to all the evidence being introduced that Mr. Gibson wanted to. But we think the record is very clear that he did establish his residence. And I think the whole argument that he made in his summation, the court will notice, was his motive. It goes to motive, and that's where he has a problem with it. He basically said, well, if that's what the law's going to be, then I'll go do it too. And he's certainly able to do that if he had done it before. We just ask that the record be reviewed by the court and that you uphold the record that is established and uphold the decision of the Board of Elections that said that Mr. Al Tillman was a proper candidate in this election. Thank you.
All right, you want to close it, Mr. Scott?
Yes, very briefly, Your Honor. Mr. Nolan asked why you would want to remand, and I think when the court reads the record, it will be clear that although the board did not show Mr. Gibson, you can't say anything else. It's obvious that they're not going to consider certain things. The statute 21-2-6C places on the Board of Elections the obligation of determining if the candidate is qualified if he's arrested. That's not Mr. Gibson's obligation, that's the board's obligation. And then 217 lays out all of the considerations that the board is supposed to consider. The board zeroed in by the comments of at least two of the members who voted in this case, zeroed in solely on the homestead exemption. But why does Mr. Gibson think a remand is appropriate? And I can't introduce evidence here. I can proffer you what we would hope to do. And what we would hope to do would show that, you know, as of yesterday, Mr. Tillman may be paying bills at the apartment on Bluefield Road. He and his wife are also paying the garbage bill and listed on the garbage bill for his residence at 2572 Robin Hood Road. They own that property together jointly. The business that Mr. Tillman's discussed, his business, he doesn't mention the name of it. The only business that is appeared to be associated with Mr. Tillman, I would proffer, would be Tiger Entertainment, which is the business license is held by his wife. That business is located at Robin Hood Road in District 8. And we would like the ability to show the court any other business for which Mr. Tillman may be involved, even if it doesn't have a business license to operate in Bacon or Bibb County, that is also located in District 8. And so those are other considerations that we believe would show that really all that occurred at the hearing was Mr. Tillman getting an apartment, putting 4 or 5 suits in a closet, taking a picture of it, putting 2 pictures on a refrigerator, taking a picture of that, putting some food in a refrigerator, taking a picture of that, and saying, well, I live here now, but the facts don't bear that out. Thank you.
All right, let me add to all the lawyers, let me add is, and it's been a long time since I've heard an election contest, is this de novo or is it a true appeal? What?
It is not de novo. So it is
It's
a
really
true
an
appeal.
appellate, a true appellate review.
That is correct.
And then is the standard, what's my standard of review?
Well, Your Honor, I'll read it out of the statute. Well, the statute just says that it shall be confined to the record, and the court shall not substitute its judgment without a superintendent asking the weight of the evidence on questions of fact. And I think that case law that looks at that type of standard is going to basically look at any evidence type of standard.
Okay, so it's a lot like workman's comp and other.
I think the standard is similar to a lot of other administrative type appeals that come before the court.
Right.
And I don't disagree with anything that the cops just said. He certainly has quoted the law correctly, but there's a little more to the standard as to whether this court may reverse or modify the decision. What it says is this: the court may reverse or modify the decision if.
Where you reading from?
I apologize, Your Honor. This is a 21-2-6 subsection E. It's the same exact place that Mr. Cox was reading from, just going a little further, and it's at tab 10 in the notebook I handed up. The court may reverse or modify the decision if substantial rights of the appellant have been prejudiced because the findings, inferences, conclusions, or decisions of the superintendent, who's the board in this case, are, and then it lists 6 things. 1, in violation of the Constitution or laws of this state. 2, in excess of the statutory authority of the superintendent. 3, made upon unlawful procedures. 4, affected by other error of law. 5, clearly erroneous in view of the or arbitrary or capricious or characterized by an abuse of discretion or clearly unwarranted exercise of discretion. And the reason I go through all those is because I think that really illuminates the standard, because Your Honor and all the lawyers in this room certainly have heard these phrases over and over again, and we all know what they mean: abuse of discretion, arbitrary or capricious, clearly erroneous, in excess of the authority. So that is the type of standard, and that goes along with what Mr. Cox said, which is important to defer to the fact finder, which is the board.
Anything that's here?
John, again, I would just reiterate it. I think it is in any evidence type rule as far as what their decision was. I don't think it stops there. I think you do have to make a determination as far as whether or not it's also supported by the legal standards that are set forth in the statute. If we think that they clearly are.
Well, just like Wisconsin, any evidence supporting that.
Correct.
There's a, we all say any evidence, but there's a little more to that phrase than
There is.
just any evidence.
And I
Any
think,
evidence supported that.
and I think it's set out in the handout case, which you've got a copy of. It's clearly set out.
All right, what I'm gonna do is, hold the record open till Monday, council submit proposed orders and any letter brief or things you would like for me to consider. I've given each of you a card that's got an email address on it. Get it to me by email and proposed order, and I'll issue an order, because Mr. Gibson and Mr. Tillman are entitled to and the people of Bibb County are entitled to a decision fairly quickly. So this is not something we're gonna drag around. Get it to me by Monday.
Thank you, Your Honor.
Anything else, Mr. Cox?
No, Your Honor, thank you.
No?
Thank you, Your Honor. Thank you.
Aaron? All right, question recess.
All right.
ECU.